Hello, beautiful people. Welcome back. The United States Constitution. What is the difference between a grand jury and a trial jury? Most certainly at this point, a lot of us have heard of grand jury and trial by jury. There's regular jury and there's grand jury. The presumption here is most of us know that the word grand simply means big. Those two types of juries are different, and one of them is grand for a good reason, and the other is just a regular jury for a reason. There's a significance in those two specific titles that are distinct, and these distinct titles of grand jury and a jury are spoken of in Amendment 5, Amendment 6, and Amendment 7 of the United States Constitution, and there are respective versions in the state constitution also. These things called laws that preserve certain rights, that act as a road sign to say, hey, see that over there? That's where you go. That's how you do it. And this is why you do it. Most people tend to misinterpret it just as much as when they see someone, say someone wealthy or successful. They see their physical appearance, they see their vehicle, they see their house, they see them spending money, and they go, wow, look at that car, look at that house, look at his car, look at her house, look at her dress. Not once do they ever go, wow, look at their mind. Because the way that they're able to obtain those wealth and glory that everyone is now able to bear witness to, it's because of something else that that man or woman cannot quite physically touch. That thing that everyone else is bearing witness to is a mere effect of something else. The difference between someone who's successful or wealthy, one way or the other, wealthy is just a after effect of success, and it's not success itself. But in this given instance with pen and paper, those who really get things done, what people fail to realize is when you listen to someone explain something, or what you observe when someone shows you the end result, not just flashing some image in front of you and throwing you on their hype train, but they're showing you the actual end result and the step of how they get there. Those things themselves are an after effect of something else that took place in the mind of whoever it is that's showing you. This is the reason why we do what we do here, to show you those steps of that cause to get to the effect, which is the success that you desire. There's a problem that many people are currently facing. People are stuck on the whole trial by jury is different from jury trial. Let me tell you something about that. Where equity sits, that makes no difference. That's right, because it's going to be construed based on the capacity of one, those people sitting as jury, and two, you, the one who they are determining certain things against. So if you don't know how to pick jury and the importance of how to actually get your peers to qualify and act as a jury, you're screwed. You can use the buzzword trial by jury versus jury trial all day long, and you don't know how to pick a jury. You don't know what a jury questionnaire is. You don't know how to schedule that thing called voir dire. You don't know the intricacies of it, how to come together with people to actually get to the selection process whereby the court itself will have no choice but to pick the people that you propose. You don't know all that, then you're still intellectually jacking off. But in this case, let's just presume that you know all of that. There's an issue going on right now where certain laws are being created to the detriment of you and I. And if you don't know the foundational difference between a regular jury and a grand jury, that thing reaffirmed within the First Amendment called the right to petition grievance, whereby Congress shall make no law respecting establishment or prohibition of the free exercise of the press or the right of the people to peaceably assemble and to petition the government for redress and grievance. Everything else that is in the 2nd, 3rd, 4th, 5th, 6th, all the way to the 10th Amendment, aka the Bill of Rights, believe it or not, is encased during this first one. But in this given instance, what we're speaking about is the grand jury and regular jury. So what is the difference between a grand jury and a regular jury? And as we go over these differences, ask yourself why whoever or whenever you figured out that someone told you or you read somewhere that trial by jury is supposed to be different from jury trial, how come they're just stuck on that and left you with that puzzle piece that kept you confused and vague to a point where your subconscious mind just dumped it to the side? You just forgot about it and you got distracted with other things and you never concluded that. It's because it was insignificant. This is the raw truth. Where the delineation really truly is, it's a difference between grand jury and regular jury and how they can be used based on the right of petition by coming in as one of the people, based on due process and the preserved Ninth Amendment right, where the right is reserved to the people. The Fifth Amendment, trials for crimes, compensation for private property taken for public use, meaning usufruct, and crime. Those are the two main things spoken of in the Fifth Amendment. Remember, according to Rule 2 of Federal Rules of Civic Procedure, there's only one form of action, which has been incorporated into all the other states based on incorporation doctrine. There's only one form of action, and that is civil. So now there's this algorithm whereby they say in order for you to bring criminal charges, you will have to use a prosecutor, right? They turned the court system into FUBU, for us by us, which is also where the concept of sovereign immunity comes in with the 11th Amendment, whereby things cannot be brought against one of the United States. The fact that you will have to use a prosecutor, one of their British accreditation registered member, to sue anyone on a criminal level, this right here, crimes, is letting you know that there's an element of sovereignty involved and you will have to go through them to hold them liable. That's basically what that means in the 11th Amendment. But did you know that before that 11th Amendment came forth, whereby they say now there's only one course of action, which is civil action, and if you want to bring criminal action, you have to go through us to hold one of us in our enclaves and then their employees and representatives liable. Before that existed, this thing called the Fifth Amendment pre-existed it. And it gave you everything that you need as a starting point to know how to hold people liable for crimes. You see, what they're doing is criminal in nature, either through mortgage, either through arrests that are unlawful, either through contracts, one way or the other, either through child support. Think of it. There are criminal activities involved in it. And you're wondering, well, how can it be done without bringing in a prosecutor? Or maybe you just never wondered why, and you just never even figured out these intricacies that we've just spoken of. Well, here it is right here. And if that's not your concern, and you see that certain legislature are being created to the detriment of the people, now and in the future, and they intend for it to be permanent, how do you change it? It's called right of redress and grievance. And see, that right of redress and grievance has to be paired up with something else, because liability compels performance. And when you intend to petition something to say something is not right and it must be changed, it has to be paired with something that will compel that performance of what you perceive to be changed, because the so-called government is truly amendable to the people, because it's all about trust and contract. Unless you show that someone can be held liable, no one will perform. The only way that you can show that someone can be held liable, and the only way you can actually hold anyone liable, is your competence. Not what you say you are, not some title that you're saying you're coming through, not some processes that you say you've done. but what you actually know and what you're able to do at large. No person shall be held to answer for capital. Capital means murder, something serious that puts threat of life into the equation or affects the general mass at large. That's what capital crimes are. No person shall be held answer for capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Meaning grand juries. A grand jury is a body that is used to bring criminal charges against people through two different avenues: presentment or indictment. These two distinctions we'll be going over on Patreon in the future. But the main subject matter here, to not provide too much information and confuse people, is the fact that there's a tool you can use to bring criminal charges. And it sits right there in fine print, word for word. And the only way you would want to put to use this grand jury is as a means to compel for performance for something else that you want to change in society. You're saying you're one of the people, you're saying you have rights, right? Then change what's going on. Because the only reason why these tortfeasors are comfortable is because you are comfortable in stupor. You are comfortable in delusion. You are comfortable with temporary instant gratification, with someone giving you a lollipop and telling you to wear a pink tutu and telling you, okay, you have this pink tutu on and you have this lollipop. Just take the sucker, because you're a sucker anyway, so you'll be fine. Don't worry. Just taste it. It feels good. Go in the sunshine. Go play, all right? Okay, go play. You know how your parents would tell you, hey, go play or go get this for me. But while you're over there getting something for them, they're having a conversation they don't want you to hear about. That's what these tortfeasors are doing for you every time they distract you and put false information out, false processes out, rather than you focusing on these things, because these things are what compel performance. These things is where your power truly lies, rather than you running away from it, looking for some quick way out. There's nothing wrong with quick way out. In fact, you deserve a quick way out. In fact, when you become competent, things will become swift and quick, as they should be. But if and when you don't get it, they get comfortable and they will keep enslaving you. And whatever you experience in your lifetime, it will be worse for your children. I'm telling you, if only you know the things that are being planned right now, publicly and privately, and stored for that child running around oblivious to things. That 5-6-year-old child, that 12-year-old child going about, what they have in store is 10 times worse than what you're experiencing during your lifetime. And the reason why you and I are experiencing what we're experiencing in our lifetime is because our parents never really figured it out. And if they did, they were too distracted to really disseminate the information properly. But you and I are in the age of technology whereby someone can make a video like this and reach you in a completely different part. If you're not taking advantage of this, then something is seriously wrong. Don't worry, discharge exists to remove bills of liability. Those things exist, but they're not going to be spoken of here. And when they are, you're still going to have to get it beyond someone just spoon feeding you or giving you some cookie cutter, or you thinking someone owes you time and energy. But let's not deviate too far. Grand jury is a means to an end to compel performance for any given activities with any given experience that you, that one man or a group of people coming in as the people, whether you do it as one or as a large group, this is a tool you can put to use as a means to an end. Grand jury is how you invoke criminal charges against tortfeasors. On the Patreon page, we went over tortious interference as a means to enforce private contracts. That ties into this as a whole. And these two mediums that are grand juries are invoked, we'll speak about that on a different platform. Here on YouTube, here's what you need to put into consideration if you want to speak of jury. Don't get lost in the sauce of trial by jury or jury trial. All that, if someone hasn't said it as of yet, it is pure trash. Don't get lost in the sauce. It's the substance that matters, not the form. And the substance is based on what you know, and most importantly, how you can apply it to your specific circumstance and how you can make that permanent. Like they will make any given law and make it permanent based on full faith and every state can enforce it. Why aren't you doing that, the everyday man who say you have rights? Put that into consideration. No person shall be held to answer for capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. In the past, we went over about 25% of what it really takes to select any type of jury. It's called voir dire. There was about 4 or 3 different parts of that here on YouTube around last year, July or August. Except in cases arising in the land or naval forces, meaning their military force and military law that governs military activities compared to civilian activities, or in the militia when in actual service, time or war or public danger. That right there is the first few clauses of the Fifth Amendment that lets you know if you want to bring crime against someone and you're not invoking military jurisdiction, it's called grand jury. Now, if it involves the taking of human life, then you don't need an indictment or presentment because it's prima facie on its face. And it can be done straightforward and way more arbitrary. But then there's this other thing called jury trial or trial by jury that a lot of people go on about. And somehow, some way, they ignore this thing called grand jury. So let's talk about that. It's in the Sixth Amendment, right of accused persons in criminal prosecution. They both speak about crime and criminal related matters. So keep that in mind. It is the point at which they make their decisions, the type of juries, that makes one grand versus regular. In all criminal prosecutions, the accused shall enjoy the right to a speedy public trial by an impartial jury of the state and district wherein the crime shall have been committed, and district shall have been previously asserted by law. Meaning when it comes to trial, there is a separate jury for it. When it comes to establishing criminality of something, there's a separate jury for it. It also mentions trial jury in the Seventh Amendment. Rights in civil suits. In suits at common law where the value in controversy shall exceed $20. Based on inflation and quantitative easing, this is probably around anywhere from $400 to $800 now. The right of trial by jury. Trial by jury in civil suits in criminal prosecution shall be preserved. It's a preservation. See, the thing with this Constitution is it really doesn't tell you the definition of things. It really doesn't tell you how to operate it. It just gives you the general outline of it. If you're taking this for face value and you're running around trying to slap people with it without knowing what a jury is, how to create a jury, how to pick it, how to organize it, how to put it to use, or even that thing called probable cause, what it means, all that stuff people just throw it around and say this is my right. If you don't know the intricacies of it beyond what's on its face and you think it's self-executing, you are still lying to yourself. Cease doing that very quick and solutions will run to you. So the Seventh and Sixth Amendment speaks about jury when it comes to trial itself, whereas the Fifth Amendment speaks about grand jury. as it pertains to the initiation of criminal prosecution. In truth, that really basically explained the two differences to you. But in case it's still not clear, what is the difference between a grand jury and a regular jury that deals with trial? Those are the two distinctions when it comes to jury that you and I should worry ourselves with, rather than the trial by jury versus jury trial stuff that people have been stuffed with. It's just some conjecture, some intellectual masturbation somewhere that everyone just spoke about at one point and just kept quiet about it and just kept moving. That's detrimental. That thing called tyranny that everyone wants to avoid, that's how they thrive. They feed you the wrong information, and they know that that fire of that wrong information will not last long and cannot hold them liable. So now that that distraction has been entertained when it comes to trial by jury versus jury trial, here's the real thing. The real thing you should be worried about, or at least the real thing you should be competent of how it exists, of their existence, before you even learn how to apply it, is grand jury and jury when it comes to trial. Those are two different types of juries that serves two distinct, significant difference. The significance of a grand jury is as simple as this. That thing called probable cause, spoken of right here. They place these things in certain order for very good reason. The way one arrange and prioritize information in legalese has a lot to do with the order and increments of how things are processed, aka the process itself. The right of the people to be secured in a person's houses and papers effect against a reasonable search and seizure shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or thing to be seized. Do you know the reason why this probable cause clause and the affidavits that support it and the warrants regarding it is mentioned right before grand jury? That is because grand jury, when it comes to the establishment of crimes, are the ones that establishes probable cause for a case. The issuance of warrant upon probable cause, supported by oath or affirmation, describing the place to be searched and things to be seized, aka the summons. See, when you begin to read the rules regarding indictment on the federal level, you realize that they can effectively circumvent the requirement for summons so long as an indictment exists. Did you know that? That is the reason why most people get indicted on criminal stuff and they never get set summons. And that indictment just sits there privately for years after years, and they just smack you with an arrest. Once an indictment is initiated when it comes to the supposition of criminal matters, they can substitute a warrant for a summons. Meaning they don't have to send you a letter saying, hey, come show up here. Instead of saying, hey, come show up here and answer to these things, they can snatch you up according to the language of how they do things. Is that right or wrong? We're not saying it's right or wrong. But what we are saying here is if you don't know it exists, how can you fix it to make it right or wrong? You know how many millions of people have suffered from that thing that we just explained regarding just being snatched up outside of some private indictment? Because grand jury deliberations are private. They don't disclose that in the public. And if grand jury deliberations are private, do you now see the importance of knowing how to pick them and put them to use based on what benefits you as one of the people is very important? Because that's exactly how it's supposed to be. You, the people, are supposed to have private deliberation as to the matter of society that other quasi-political bodies cannot intervene in. And you can use that power to bring criminal charges against those who are affecting the interests of the public at large. Yet they are switching it against you and are screwing up a lot of people's lives using the same tool that was designed for you to use. But if you don't know it even exists and that you were meant to be the one to use it, and you're stuck on some catchphrase, some buzzword, jury trial versus trial by jury, how in the world can you ever even put this tool to use? This presentment is synonymous in many cases with summons. And the requirement of summons is synonymous with the requirements of warrants that's spoken of in the Fourth Amendment. So now you see that all these amendments are actually one thing. They're like Voltron. They're not separate. They're all one. They just delineate it into different parts just for the sake of simplicity. Because if this were to be written in one paragraph, it might confuse people. Even this right now is confusing some people. Because obviously if it's not confusing people, people would have figured this out long ago. And there are those that have figured it out, but they're not talking about it. And those that are close to figuring it out are used as agents of misinformation to throw you some lollipop or something bright and fancy for you to chase after. In summary, a grand jury brings criminal charges against any given tortfeasor. A grand jury is your way to bring charge against people, but you have to know how to create one and how to pick one, don't you? A grand jury is the body that establishes this probable cause that's spoken of in the Fourth Amendment. A jury, when it comes to trial, on the other hand, determines the outcome of the evidence that's been provided in place of the judge or in conjunction with the judge's guidance, if you allow that to occur. Again, a grand jury determines whether the case should even start on a criminal level or not. Either privately, aka indictment, or publicly, aka presentment. Whereas a jury, when it comes to trial, determines the outcome rather than the establishment of the beginning. A jury, when it comes to trial, determines the outcome based on a preponderance of evidence. Those are the two differences between grand jury and regular jury. And it's given to you in fine print. Any given situation that you're dealing with, if you say, you know what, I don't even care about money. I don't want damages. I don't want to claim damages. I don't want to claim private damages, irreparable damage, future damages, statutory damage, or actual damage. I don't care about that. I actually want to see this man or woman in jail. This is what you need to be looking at. Or you go, you know what, there's a language of this law that's going on right now that's not beneficial to me. And yes, I'm going to be writing this grievance and redress based on the right to petition the First Amendment. But how can I compel them to respond? How can we compel them to respond? It's called a grand jury. Let's go more into the details. Grand jury. As always, hop off Wikipedia's nuts, because the reference to the things that are being explained are put in asterisks. And those same asterisks, you can go to the reference at the bottom and look at where the sources come from. The sources of this is coming from the Grand Juror's Handbook, from the federal court system, in certain states like Virginia, and counties like Hennepin County, and other states like the Grand Juror Handbook in Illinois. It gives you reference to state common laws and archives and many other tools along the explanation, and books written on the same matter. So again, hop off Wikipedia is nuts when it comes to it's not accurate. And, okay, cool. Don't use it. You keep doing what you do. Don't read. A grand jury is a jury. What is a jury? A group of citizens. It's that simple. All that try by jury trial. Look, that's a bunch of mental masturbation somewhere that's distracting you from actually focusing on the main thing. A grand jury is a jury, a group of citizens, empowered by law to conduct legal proceedings. In other words, we the people. Investigate potential criminal conduct. Investigate, meaning you can find the root cause of what some criminal activity is, and determine, meaning the final outcome, whether the criminal charges should be brought, aka probable cause. In order for the cause to exist, where the probability of a crime actually took place or not, you have to investigate the conduct of itself. That's a lot of power. And it has to be involved in some form of legal proceeding. By whom? The people. A grand jury may subpoena physical evidence or a person to testify. Remember, this is just for the purpose of establishing probable cause alone. A grand jury is separate from the courts. A grand jury is separate from the courts, which do not preside over its functioning. Did you just hear that? In other words, a grand jury is private. This is the reason why when you will read the language of each state and on the federal level regarding grand jury, they will tell you that their deliberation and minute of grand juries are private. Or if you read any indictment on the state, county, or federal level, they will let you know that the deliberation of the grand jury is held confidential. The question to you now is, you're saying you're a private man, or you want to be private, right? Why aren't you doing this with other people that are private? If one doesn't even know it exists in the first place, then they will subrogate you and use that system against you. Do you know that when people get letters in the mail saying, hey, come do jury service, that's just jury trial? Not they. The percentage of people that get information in the mail to say, hey, come serve in jury, only applies to jury trial and not grand jury. So the question is, who are these grand juries? These same attorneys that they're saying go to bring criminal charges, to be able to prosecute other people, are the same one playing the role of grand jury. They're playing your role. Because you have abandoned your power. Since grand jury is private and separate from the courts, they're not obligated to show you anything. But guess what? As one of the people, if you come in and demand that, you know what, this is our capacity and we want to see who's been controlling it, then you will begin to change things. But if you don't even know that that necessity exists, how can you do anything? Again, these tortfeasors are comfortable because they know you cannot criminally hold them liable. Because simple, basic one-on-ones like these are not even known. People feel like doing things to throw them in jail because they know that they've been wronged. But how? They don't know. And when they ask the questions on social media, or when someone tells them something, they run them through the rigmarole of a bunch of hype train and useless trash. Some false promise. Some, hey, look at me. No different than when you look at someone driving a vehicle or having a big house. You're looking at the wrong thing. What you should be looking at is what they know in their mind that got them to have those things. And most of these people that will give you this cute lollipops and pink tutus, when you begin to go into their mind, you realize they don't know jack. They read it somewhere and they're able to just present it to you and sell it to you in such a way that appeals to your own hype train in you, that need for you to do something, that fire. They take your money, run away with it. At the end of the day, what can you show for it? Nothing. It shouldn't be like that. Originating in England during the Middle Ages, grand juries are only retained in two countries, the United States and Liberia, which, by the way, Liberia is a colony created by some, quote, African Americans who effectively enslaved their own brothers and sisters in that part of the world through the support of the so-called people that were supposedly enslaving them here in North America. But that's a whole nother story. Other common law jurisdictions formally employed them. Common law, everyone talks about common law, common law, common law, common law. And you're not speaking of grand jury, or you don't know grand jury. You're just on the hype train. You're not doing anything. Other common law jurisdictions formerly employed them, and most others now employ a different procedure that does not involve a jury. Meaning it's been so dormant that people are not using it, that a substitute aspect has to now come to life as a solution to the dormant state of that thing that primarily is used as a tool to bring criminal charges against the people. It still exists, but if one doesn't know the tool exists, how can they pick it up and put it to use? And when that tool is put to use, it will be used to your detriment, just like they do today. Don't they bring indictment against people arbitrarily, privately? Sure they do. And in many cases, they just say, screw it. We're not even going to go through indictment. We're just going to say you did this criminal act and yeah, go to jail, pay us fines. What you're supposed to be doing to them, they're doing to you because you've ignored your power. And from that power being ignored, they call that different procedure, which is a substitute. They call it a preliminary hearing. You've heard this word before. I know you have. Preliminary hearing. Pre-trial. Yeah, we've heard this word before, haven't we? Grand juries perform both accusatory and investigatory functions. The investigatory functions of grand jury include obtaining and reviewing documents and other evidences. Remember, grand juries are a group of citizens, not lawyers. Those same group of citizens, aka we the people, have the right to conduct legal proceedings, investigate criminal conduct. So you would have attorneys quick to tell you, look, you have to be an attorney to do this and do that. They're trying to distract you from your true power. That you need some piece of paper that says you belong to some organization to conduct your affairs amongst your fellow man and society. Yet, people in North America, where this thing called grand jury existing as one of the two countries, United States, that does business in North America. Yet, these people, these few countries that retain this thing called grand jury, which is a perfected system of government by the people, for the people, that you will not find in the majority of part of the world. Only two countries retain the use of it. And the United States that does business in North America, the people at this North America, the same people that are quick to tell you we're the best in the world, we're this and that, everyone want to be like us. Yet, you are incompetent about how your law works. Something is seriously wrong. Are you really the best in the world if you don't know about how the basics around you works? Something is wrong. The people that you're supposed to be controlling are creating colorable alternative means to kick your ass every day. Your brothers, your father, your uncle, your sisters, your grandmother are getting their butts kicked. Because of incompetence. And because whenever they create substitutes, they have to create a way out to make it easy for you. And this thing called preliminary hearing is also used to serve the same purpose that a grand jury will do. What is the definition? It tells you within some criminal justice system, a preliminary hearing, preliminary examination, preliminary inquiry, evidentiary hearing, meaning rules of evidence, or probable cause hearing, which is the same thing that a grand jury does. They establish probable cause by investigating the criminal conduct through legal proceedings. One of the people. There's a substitute for it called preliminary hearing where they now take over it, aka the acting judge, if you fail to invoke the power of grand jury by bringing in your own peers to determine whether probable cause for a criminal activity has even exists in the first place before anything starts to go on, before a trial, which even at that point, your own peers can still come in to determine the outcome. And because they've created a substitute of it, they provided you this thing called the rules of evidence. Because this thing called preliminary hearing, which is a substitute for what grand jury does, is also called evidentiary hearing. Evidence exists to substantiate what you come in to say is a proof of why you're guilty or not guilty. You see the reason why we go over the rules of evidence now? Because the issue has to be dealt with in its immediate circumstance and then walk you to the solution. If you just want to start with something else without knowing where you're coming from, you would not get there. Because there's a lot in between that you need to know. If you know how or why things function now, you can backtrace it properly, and it will make more sense as you backtrace it, rather than just hearing someone tell you something. This is the reason why we go over the rules of evidence. All of this are not isolated. Again, grand jury establishes probable cause before any criminal case begins. Jury, when it comes to trial, determines the final outcome and determination of that thing called probable cause that's been decided by the grand jury. But since people have abandoned the power of grand jury and jury, they create a substitute aspect for it called preliminary hearing, aka evidentiary hearing, to which its backbone are the rules of evidence, state or federal level. Grand juries perform both accusatory and investigatory functions. The investigatory functions of grand jury include obtaining and reviewing documents or other evidences. At this point, those bar member attorneys are the ones that do this, not you, the people, because you, the people, have abandoned this power. The investigatory function of grand juries include obtaining and reviewing documents and other evidence, and hearing sworn testimonies of witnesses who appear before it. The accusatory function determines whether there is probable cause. Same thing preliminary hearing does, aka probable cause hearing. Do you see the dynamics of the substitute that they've created because you and I have abandoned the power we have? And how they're using it against you and I, the one who holds the true power. The grand jury investigatory function includes obtaining and reviewing documents and other evidence and hearing sworn testimonies of witnesses who appear before it. The accusatory function determines whether there is probable cause to believe that one or more persons committed a particular offense within the venue of a district court. Here's a doublespeak for you that they've implemented into this last sentence that we just read. District court refers to military jurisdiction. And we read earlier that grand juries exist with exceptions of military related matters. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of grand jury. Meaning, if it involves human life, you don't even have to try to figure out probable cause because it's clear. If it's clear that they did it, no need to even establish probable cause because it's right there in his face. Otherwise, if it's not clear, then go through a grand jury. But the only situation you cannot go to a grand jury, which is the exception that they gave here, is except in cases arising in the land or naval forces or the militia. The term district has to do with military subdivisions, which was initiated based on the Judiciary Act, just a little bit before and after the 1791 United States Constitution was ratified. You see how they are playing their chess piece? Whereas you and I have been dormant in making our moves. So now they're effectively homogenizing things that act as exception to the power that you have into that same power that you have in and of itself. But if you don't know these things exist, how can you ever stand up and speak up, let alone put it to use? Purpose. The purpose of a grand jury is to accuse persons who may be guilty of a crime, but the institution is also a shield against unfounded and oppressive prosecution, meaning it's all based in equity. It is a means for lay citizens, meaning you don't have to belong to some professional club. You don't have to have gone to school for any given amount of years and be groomed to be part of this, to hold this title in order to be able to make a decision as to the peace and dignity of society that you belong to and that other man also belongs to. It is a means for lay citizens representative of the community. Just like the Second Amendment speaks about militia, but then there's also some aspect of it whereby you can come together based on the community. The term they use for that is posse comitatus, which we went over in the video regarding Second Amendment and misunderstanding of how it grants right to bear arms, whereas there's specific types of arms that can be granted, and that's still lingering based on Supreme Court case as of 2021. A grand jury is meant for you to have the power to legal proceedings and to determine who's guilty or not, for your benefit, for the benefit of your children, the benefit of everyone else. Yet, when you think about bringing criminal prosecutions, they'll tell you, well, you got to use one of our attorneys. They will never tell you about a grand jury. Why should they? Because it does not benefit them to tell you about it. But instead, what they'll do is they'll send agents of misinformation to you to tell you, oh, trial by jury is different from jury trial. And you're stuck on that one, rather than focus on the fact that the two main types of juries that exist primarily are grand jury, which establish the probability of someone being guilty to initiate things into trial, which at that point, even during trial, to test the sufficiency of whether they should finalize the guilt or not, would also be by the people, from the beginning all the way to the end. But what do you see when going to courthouses? All you see is attorneys. But bear in mind, it tells you the grand jury is separate from the court. The grand jury is separate from the court, which do not preside over its functioning. This is based on res judicata, United States versus John H. Williams, year 1992. So if you're going to speak of judge-made law and all that, at least seek for the right things within it rather than just throwing that word around. What you know is a reflection of the world that you create. People's suffering in today's world is based on what they don't know and the world that exists in their mind. We have to do better. It is a means for lay citizens, representative of the community, to participate in administration of justice. It can also make presentments on crime and maladministration in its area. Maladministration is another word for trust-related matters that is being handled incorrectly. So you can set people straight based on the right to petition in government and to seek redress and grievance based on grand jury, as mentioned earlier, to compel performance. Traditionally, a grand jury numbers 23 members. The mode of accusation is by a written statement of two types. In solemn form, called an indictment, describing offense, proper accompaniments of time and circumstance, the certainty of acts and persons, or by a less formal mode, which is usually the spontaneous act of grand jury called presentment. This is exactly the same thing that's mentioned right here. No person shall be held to answer for capital or otherwise a famous crime unless in a presentment or indictment of a grand jury. It goes on to say no indictment or presentment can be made except by concurrence of at least 12 of the jurors, meaning a little bit more than half of them. The grand jury may accuse upon their own knowledge, but is generally done upon the testimony of witness under oath and under evidence heard before them. Grand jury proceedings are, in the first instance, at the instigation of the government or other prosecutors, and ex parte in secret deliberation. There's the double speak again. Grand jury proceedings are in first instance at the instigation of the government or other prosecutors. Do you know who the government is? You. And secondarily, they tell you, or prosecutors, which is what they will usually put in your face all the time. Prosecutors, you want to bring criminal charges? Prosecutors, prosecutors. And are ex parte in secret deliberation because it's private. It can only be lawfully ex parte, meaning without the other party, if it truly involves one of the people. But I'm telling you, the people that participate in these grand juries are members of BAR, of British Accreditation Register members. They don't care about the everyday man and woman. But why should they? Because the everyday man and woman don't even care about themselves or their rights. They claim they do, but truly they don't. The everyday man and woman is stuck on looking for some quick way out. Which is fine, you can do that too. You have the right to. Let's see how far that takes you. The accused has no knowledge nor right to interfere with their proceedings. This is a lot of power. Power that's supposed to be used by we the people. If they find the accusation true, which is usually drawn upon and formed by the prosecutor or an officer of the court, meaning now a trustee relationship exists. After they've made their private deliberation, they now hand it to the court and their representatives. Remember, a grand jury is separate from the court, which do not preside over its function. Meaning the decision that will be made in secret is supposed to be absent of these prosecutors and officers of the court. Now, when the decision has been made, it's handed to them as a trustee to initiate the public suit. They, meaning the officers of the court, after the private deliberation of the everyday man and woman, the layman and woman, their decision is given to the officers of the court. They, the officers of the court, write upon the indictment the words, "a true bill." which is signed by the fourth person, meaning a third party witness, of a grand jury and presented to the court publicly in the presence of all the jurors, meaning it's now a verification process. If the indictment is not proven to be to the satisfaction of the grand jury, the word ignoramus, or not a true bill, is written upon it by the grand jury or by their foreman, their neutral third party, and then said to be ignored, and the accusation is dismissed as unfounded. We'll stop here on YouTube, and we'll be going over the deeper details on Patreon. Whatever the situation is, know that a solution exists, and your competency is the first stage to it. Hey, beautiful people, I'm inviting you to come join my Patreon page. We speak about everything we don't speak of here on YouTube on the Patreon page. We speak of establishing privacy in many different means, how to hold tortfeasors liable, the different types of discharge, and the steps to actually do it. Now I'll be showing my own proof of the success, the intricacies involved in why and how it works, and the things no one else would tell you because they've never discharged themselves. The intricacies of settlements, suing people, and many other basic things like other tools that you can use privately, things of spiritual nature, because this goes beyond what you observe with your five senses. And if you just want to limit your remedy to just what you observe with your five senses, think again, because the other side is not playing in that realm. It's not an even playing field. Other things like study tools are shown things regarding trust and asset protection, and how to lay your trust properly the way people seek it, and the advantage of how to do it, banking, the functionality of how they function, and the validity of it that a lot of people misuse or are misled by, where they think, oh, these other guys are bad, so now I have to just go into argument mode. No, you don't always have to argue. The law is perfected for your benefit if you're competent about it. Many things regarding child support, different examples of settlement checks, and the videos on it, the different aspect of how you can broaden your mind internationally beyond the little chicken scraps that people are picking up when it comes to passport and things of that nature, how banking work, how property protection work, the details of copyright, tort, privacy, different types of trust, the intricacies, and exactly why and how they are done, the intricacies that people from other parts of the world know about trust that you don't. Just because you read something on social media and whatnot doesn't mean you really got it. The intricacies of how to use certain jurisdiction and the stuff everyone speaks of. More in child support, more in trust, more in court, more in spiritual nature of things, etc., etc. The fact that tax avoidance is different from tax evasion. The importance of things in commerce and how to actually function in commerce. How to actually really do things as a natural person is beyond speculation. But let me give you this caveat. If you're looking for a cookie cutter or some quick fast food way, this is not it for you, either here on YouTube or on Patreon. But if you're serious about your education and the function and application of it, rather than the mere accumulation of information, then come on over on Patreon. There are things we speak about over there that are universally and exponentially beneficial compared to that of the ones we speak of on YouTube. And more importantly, the practicality and the actual use of it. Take care. Best of luck.